Hi. I am Fatima Zara Binti Rosley. Nice to meet you. This presentation is for an academic purpose, for the subject Law of Evidence 2. I prepared this video for Mr. Muhammad Firdaus bin Bitten. Today I will present to you the case of Maxwell against DPP, 1935, AC 309. In the case of Maxwell v. DPP, 1935, AC 309, the appellant, William Maxwell, convicted at York Assizes on February 27, 1934 with an offense of a manslaughter upon a woman, May Holliday. He also convicted performing an illegal abortion on that woman. The appellant used the instrument with the intention to procure a miscarriage, and due to his action, the woman died. The appellant was a herbalist of the age of 75 years, and on October 9, 1933 was visited at his house by a man named Wilson. Wilson, who was responsible for the pregnancy of May Holliday, together with Mr. and Mrs. Wilson, paid the appellant $4.
Thank you, Sally, for helping me just now. I'm the real Fatima Azara. Alright, let's begin. On November 17, the woman again visited the appellant. That evening, the appellant went to a doctor's house and told him that the woman had collapsed. The appellant found guilty and sentenced with 24 months imprisonment with hard labor. Due to the sentence decided by the court, the appellant appealed to the Court of Criminal Appeal. However, the court dismissed the appeal. The appellant once again appealed to the House of Lords and had given his evidence from the witness box. In his evidence and statement, the appellant contended that he had been living in good, clean and moral life. The prosecution in this cross-examination with the appellant asked him whether he had previous charge for the similar offence.
As for the judgment, the previous charge was not the evidence of bad character. This is because it did not result in the conviction of the accused. Secondly, the mere fact that the man been charged with an offence is not a proof that he committed the offence. Thus, the court opined that the fact was irrelevant for the purpose of showing that the prisoner did the act which he is actually had been tried the credibility as a witness of the accused person. Thirdly, the first principle in regards admissibility of similar fact evidence is based on the Mackin versus Attorney General for New South Wales. In Mackin's case, it was stated that the evidence of previous killing of the other babies were not used for the disposition. However, it is used to rebut possible defense raised by Mackin when they claim that they only wish to adopt and maintain the child. They also claim that the child death was an accident.
There is no specific provision explained in Evidence Act 1950 in regards to similar fact evidence. However, Section 11, 14, 15 are usually invoked by the judge to accept the similar fact evidence in Malaysia. According to the law evidence in Malaysia, it is not capable for the prosecution to cite evidence in order to show the accused had been guilty of a criminal act. In deciding the case where the similar fact evidence had been adduced as an evidence, the Court of Malaysia especially had been very careful to admit the similar fact evidence in the sense that such evidence should not be admitted without reasonable cause. However, the decided case have been shown that the recent common law in regards similar fact evidence is widely applied to the extent disregarding the actual position of Evidence Act 1950.
Alright Fatima. Let me explain this part. The character evidence in Maxwell's case can be seen when the appellant contended that he had been living in good, clean and moral life, which means he had raised a defense of good character. Thus, the accused was fairly cross-examined by the prosecution to show the contrary. Next, the existence of character evidence in this case is when the prosecutions highlighted the evidence of past conditions of the accused to shake his credibility as a witness.
I agree with the court, which, if the contention by the prosecution was allowed, they are likely lead the jury amiss into false issue and statement, and also thought towards the accused, and tend to introduce suspicion and tend to distract jury from the true issue. It is important for a fair trial because the evidence admitted in court should be prima facie limited to matters relating to the transaction which forms the subject of indictment, and to any departure from these matters should be strict confined. The court really upheld the right of the accused when the court used its power to forbid questions of the past conviction by the prosecution in order to shake the accused's credibility as a witness.
Thank you for your time. From Sally and Fatima.